All right. Well, good afternoon, everyone, and welcome to the National Conference of State Legislatures Supreme Court preview. I'm going to keep my opening remarks really brief. My name is Susan Frederick, and I am one of the staff people who work with the Law, Criminal Justice, and Public Safety Committee. And I'd like to welcome our other members from our team, Allison Lawrence, who will be manning the waiting room, Lucia Bragg, who will be looking at for your questions, which I hope you will put in the chat box when you have them. And without further ado, I'm going to go ahead and introduce our presenter, Lisa Soronen. She is the Executive Director for the State and Local Legal Center. The State and Local Legal Center, or SLLC, files amicus briefs on behalf of the 7 national associations that represent state and local elected officials, NCSL being one of them. And without further ado, I'm going to go ahead and turn it over to Lisa. She's got a very, very thorough presentation on what we can look forward to this year in the Supreme Court. We have a new justice coming on board and lots of interesting cases. So Lisa, take it away.
Thank you, Susan, and hello, everyone. What an auspicious time to be talking about the Supreme Court. I feel that I should almost turn my paycheck back in for this week because it's such a pleasure to be able to talk about the court at this particular moment in time. So I'm going to cover a lot of topics today in a short amount of time because there is just a lot going on, but I've absolutely set aside a time for questions because I imagine there might be many with what's going on. So I'm going to start talking about the death of Justice Ginsburg, which of course happened in September. And I'm going to focus on what it means for our country, for state legislatures, for the Supreme Court, for the Chief Justice. And then I'm going to talk about that awkward topic of why she might have waited. So as many of you probably know, in the last couple of years, 2 movies came out about her life. One was a Hollywood movie and one was a biography. And I saw the Hollywood movie about 18 months ago. I'm not a crier. I'm an ENTJ. We don't have very many emotions. And I haven't cried since. And I cried the entire way home because my mom's turning 80 next week, and she and Justice Ginsburg are women of the same generation. And to sort of see what she went through personally and professionally, arguing 6 cases about gender discrimination before the Supreme Court, she's just had a remarkable life. She, of course, will be most famous for her dissents, of which there were many. I mean, imagine being on the Supreme Court for 25, 30 years and never being in the majority, hardly ever in big cases. It must have been hard. Most Americans cannot name a Supreme Court justice, and her death will only make that worse because if they could name a Supreme Court justice, it was most definitely her. So in terms of her for state legislatures, all Supreme Court justices are a mixed bag. They're good in some cases. They're bad in other cases. Like I said, Justice Ginsburg will be remembered as a liberal, as a defender of abortion, as a feminist, and those sort of things. But from my perspective, I very much saw her as a pragmatist and always hoped she was thinking in a pragmatic way when she looked at the cases where the State and Local Legal Center filed an amicus brief. I have 3 cases on the screen where I can talk about her making a difference. Because of time, I'm only going to talk about 2 of them. But the first one is South Dakota versus Wayfair. Probably everyone on the line has some familiarity with this decision. It's only a handful of years old. And in this case, the court held 5-4, and that's really important, that states could require out-of-state vendors to collect sales tax. And providing the 5th vote was Justice Ginsburg joining her more conservative colleagues. So here's the word on the street. This decision was one of Justice Kennedy's last decisions. So everyone knew he was going to leave the court on the court. And the liberal justices were very nervous about him being replaced. Again, like I said, it's just the word on the street. We don't know if this is really true. So the liberal justices were uncomfortable with the idea of siding with the state of South Dakota because it meant overturning precedent. And Roe versus Wade means a lot to the liberals, and they didn't want to be on record, with Justice Kennedy leaving, voting to overturn any precedent. But Justice Ginsburg, being more pragmatic, was like, this is a bad decision, or the previous decision. And it just needs to be overturned. And so I'm going to overturn it. I'm not going to worry, come what may. So I think that case, like I said, really sort of illustrates her pragmatism. The second case is Gobey versus Liberty Mutual. This was an ERISA preemption case. It involved states gathering data on health insurance, like how much a heart procedure costs at one hospital, how much it costs at another. And the court held, I think it was 7263, that ERISA preempted the state statute. And the state local legal center filed an amicus brief. And we had said, states need this data because they can direct people to like the hospital that's way cheaper to get help, to get a heart surgery. And Justice Ginsburg had emphatically, she was in dissent. She emphatically wrote about our brief, cited it to a couple times. And the other thing for me just personally was that when this brief had been drafted, the writer knew the subject matter very well, but didn't do a good job putting the brief together. And I had very small children at the time, and I was on vacation with them. So every weekend or every nap, every evening was done putting this brief together. And I never got it to be a great brief, but it was a pretty good brief when it was done. And I'd forgotten about that. And when she wrote that dissenting opinion, I mean, it made every nap, every night worthwhile, even though we lost. Just having her recognize the pragmatic points for state legislatures. So here's another interesting thing to think about. The court denied review of two sets of cases, if you will, right before it went on recess in July. The first set of cases involved qualified immunity. A bunch of petitions were teed up to overturn the doctrine. And 9 or 11, a large number, the court denied all those petitions. Then, more significantly, the court had, again, just a huge number of gun petitions. And 4 justices have been on the record saying they want to hear a gun case, which is enough to hear a gun case. Cert denied. So no qualified immunity, no guns. And, there were different theories as to why this happened. One of the theories, though, is that the justices knew that Justice Ginsburg's death was imminent, and they didn't know what was going to happen with the new justice, and they didn't want to put the new justice on the spot to tackle these really difficult issues. So that's another kind of interesting implication of her death. But let's talk about the big picture overall trend. What does Justice Ginsburg dying mean and being replaced by not just Amy Coney Barrett, but by any conservative? Adam Lichtak, for many of you who have heard me before, I don't know if I could do a presentation without an Adam Lichtak quote. He's from the New York Times. He said that she will move the court, this is Amy Coney Barrett, slightly but firmly to the right, making compromise less likely. This is what I totally agree with. Some of you might say, how come only slightly? Well, Justice Roberts is pretty conservative, most of the time. Also, I think it's just important to highlight the fact, as always, that most of the Supreme Court's cases are not decided on 5-4 ideological lines. So most cases don't involve, this epic struggle between conservative and liberal justices. In the time that I've had this job, I can think of 2 big cases, and only 2 big cases that weren't 5-4. So most big cases are 5-4, but there's only maybe 3, 4, 5 big cases every term. And there's 70 cases that aren't big, where that ideological divide doesn't make so much of a difference. So for those of you close court watchers, and for anyone who's been watching the news lately, you've been inundated with this. Last term was supposed to be the first term where we had 5 real conservative justices. And gone were the unreliable conservative justices. So I have them on the screen. Powell, around the time that I was born. I grew up with Justice O'Connor, of course, and then I spent a lot of my legal career focused on Justice Kennedy. They were all gone off the court. But of course, I have many asterisks here because people wondered how reliable of a conservative that Justice Roberts would be. What did he do last term? Well, he voted with the liberals. Not once, not twice, but 3 times in big cases. Now, I will remind you, there were many, many big cases. Probably a case we could call 5 or 6 big cases. But still, half the time in some pretty big cases, he was joining his liberal colleagues. The most prevalent theory on why he did this was, of course, for the Supreme Court institution. If liberals and conservatives sort of switch sides in big cases, it illustrates that the court isn't all that political. That's the going theory. The counter theory, which I've mentioned before, of course, is the idea that Justice Roberts might have been wanting to take the pressure of the Supreme Court off the election. Of course, that did not work for him, but he didn't know that in July. So let's say he really was doing what most people think he was doing, which is trying to be a justice for the institution. It paid off. and it paid off in spades. Look at these numbers. People haven't approved the Supreme Court. This is taken in August 2020. People haven't approved the Supreme Court this much since 2009. What happened shortly after 2009? Say it together, Citizens United. And look at the Democrat number. 56% of Democrats were happy with the Supreme Court. Now, mind you, some of those Democrats are going to have lower expectations than Republicans, but those numbers are awesome. And then Justice Ginsburg died, and the picture sort of changed. So this time it's going to be for real. This time it's not going to be Lisa saying, "Oh, the court's going conservative," and it's not going to happen. This time it's really going to happen. I mean, I don't think anyone thinks it's not going to happen. So what that means is that we'll have a 6-3 court in the big controversial cases. Justice Kavanaugh will become now the center judge. He and Justice Gorsuch have not done much swinging in the last couple of years. And this is very important. So far in all the big cases that he sat in, every single one, Justice Kavanaugh has voted with the conservatives. So I want to just give a moment on Justice Gorsuch and Justice Kavanaugh because we are still getting to know them. Last term was Justice Kavanaugh's first term. And they are very different. They are very different justices. But the one that strayed, it was Justice Gorsuch. And he strayed in the sexual orientation and gender identity employment case. So Gorsuch is more of the Scalia, Thomas, and Alito ilk. He's the textualism and the originalism guy. He is idiosyncratic. And I cannot pretend that I understand all his idiosyncrasies. And I think if someone claimed they could, I'd be very curious to hear what they have to say about it. For example, the court's heard maybe 4 cases since he's joined the court on tribal issues. He's voted with the tribe every single time. One of them means that for criminal law, practical purposes, half of Oklahoma will be an Indian tribe. Another interesting thing was it made the news when Justice Alito and Justice Thomas criticized the same-sex marriage decision. He didn't join that, even though, like I said, he's kind of their ilk. So the jury's not out for me on Justice Gorsuch. He's just someone I feel like I have to know better. I still think, even though Justice Kavanaugh's record this term might have been more conservative than Justice Gorsuch's, I still think he's more a Roberts and a Kennedy kind of guy. Every oral argument, he asks about the practical implications of a case, which of course warms my heart because I'm filing briefs about the practical implications of the case. In fact, just this term, he literally quoted a state and local legal center brief in asking a question on the practical implications of the case. So like that is a part of who he is. He also is very concerned, and maybe this is who he would have been before the confirmation hearings, about striking a different tone than the conservatives. In Title VII and in the DACA case, he kind of said things like, yeah, I mean, of course gay people should be covered by employment laws, but that's not our job, it's Congress's job. And DACA is wonderful, but that it's not my job to say it's wonderful. It's to say whether it's lawful or not, or whether it can be dismantled in this way. So his first term was a partial term. There he really stuck with the chief and seemed to be not more liberal, but seemed to be more moderate. But last term was his first full term. He was conservative sort of all the way. But again, he's been on the court for a year. I mean, the jury is just not out about this. So I try to include one picture in all my presentations because my husband says I should include one picture in every single slide. So I give that to him. So this Onion article is, President Obama trying to convince Justice Ginsburg to die when he's president. And, one of the ways the Onion article suggests is that she would throw herself out to wolves and just let them consume her. Anyway, it's sort of a funny article, but it's only funny, she's been dead for a while. We've had a little bit for the time to settle. There's a lot of liberals who, after time is settled, are very angry about the fact that she did not leave the court. And there's a couple theories as to why. One is that, like most Americans, she thought Hillary Clinton was going to win and that she's going to leave in the Clinton years. The second one is she's an absolute workaholic. I mean, you couldn't have the job she did without being one, but she kind of took it to the next level. And if you see the not the Hollywood version of the movie, the other version of the movie, oh my gosh, workaholic. So the other theory is this. When you're a Supreme Court justice, you're basically one of one of equal, like no one has any more power, except the chief does have more power, and his power is to assign opinions when he's in the majority. So what that means is that if he's not in the majority, someone else gets to assign the opinion, and that someone would be the most senior justice. So I'll just give you an example. A couple years ago, the court decided an abortion case. Justice Roberts was not in the majority, and Justice Kennedy was. He was the justice with the most seniority in the majority. He assigned the opinion to Justice Breyer, which quite frankly is probably what I would have done. And Justice Ginsburg, word on the street, was mad about it. And if you go back and look at that opinion, it's Whole Woman's Health versus Hellerstedt. She writes a one-page concurring opinion. It basically says, I agree with everything Justice Breyer said. Well, why would you write that opinion unless you're mad, right? So, I mean, you know, I think like liberals love Justice Ginsburg enough that they're willing to overlook her not leaving, but it is, you know, and it will probably always be somewhat of a sore spot. So what does Justice Ginsburg dying and being replaced by a conservative mean for the Chief Justice? I actually think it means a lot. So the first thing it means is that he can no longer save the institution by voting with the left in big controversial cases. I mean, he can still vote with the left, but it's not going to make any difference. The other thing too is he can no longer signal to his more conservative colleagues like, hey, let's not take this issue because I'm not sure where I'm at with it. Everyone believes that's what's happened with guns, is that he's told the court or the more conservative justices, I'm just not there yet. And this is the most important thing. And this is the thing that matters to him, I think, the most. He can no longer control the pace that his conservative colleagues want to move at. And I'll give you a great example. So when, I can't remember if it was Kavanaugh or Gorsuch joined the bench, people were like, oh my gosh, Roe versus Wade is going to be overturned. It's going to be overturned in the next 5 minutes. There are a lot of people that believe that the chief may ultimately be willing to vote in that way, but no one that follows the court closely thought he wanted to do it anytime soon. And that is something that means a lot to him, is the ability to control the pace. And that party is over for him. So people have wondered, will he dissent for institutional reasons? Will he in some instances join the liberals? I think that he rarely will, if ever. And I think this is why. His dissents will make no practical difference. No one will thank him or congratulate him for being the fourth vote when it takes 5 to win. I also think too, like this is the common theme in this, if he stays in the majority, he controls the writer of the case or writer of the opinion. And you may think, oh, that doesn't make that much difference. There are cases when it makes all the difference. There's a famous case, at least for local governments in particular, called Reed versus Town of Gilbert. It's about 5 years old. No other justice other than Justice Thomas would have written the opinion the way he did. So that is a power that the chief is not going to give up lightly and not just give up for nothing. So personally, what I wanted to see happen, I knew Justice Ginsburg wasn't going to be on the court forever. Justice Breyer also is, I think, 81, maybe even 82. What I was very curious to see what the Chief Justice would do is what would he do in a case that involved taking on the question of race directly, like an affirmative action case. I think that would have been the ultimate challenge for him in terms of choosing his own personal opinions and choosing the court as an institution. I wanted that so badly, I could almost taste it, and it's gone. Whatever he decides to do on affirmative action, it's not going to make much difference going on in the future. So for court watchers, I think that's an interesting thing. So another interesting question, I think, to ask ourselves is a 6-3 conservative court what the Chief Justice wants? I think that's the same thing as asking the question of, is he more of a conservative or more of an institutionalist? He may not know, and I know we will probably never know. But remember this, 4 years ago, he was worried about being one of 2 votes in a 7-2 Hillary court. That was 4 years ago. So you have to think about that as if you think about him processing his own role. So until October of 2020, which is right now, I have never given formal remarks on court reform. And the reason people ask me questions about it all the time, but I never put it in a presentation. And there are a couple reasons why. If you read The Soul of America by John Meacham, he talks about what really happened during Roosevelt's time. And what most people don't realize is this. It was the Democrats that went after Roosevelt and told him, no way you're going to pack the court. It wasn't Republicans. And so I didn't see court reform, court packing, whatever you want to call it. I didn't see it as mainstream, but I see it as mainstream now. I also don't really see it as likely, but I do think it's mainstream. So I think that is a reason to talk about it. I also think, Democrats, like I said, for the source of pride, if nothing else, may be interested in trying to do something. Like, I understand that. I also think too, it's really important to realize this. No one wants a 16-year-old on the Supreme Court. No one wants a 25-year-old. No one wants a 36-year-old. Someone once said, you want a justice who has definitely gone through a midlife crisis first. And my point is to say this, there always will be generation gaps with the Supreme Court. That's just the way it is. And so I wonder if we have a more conservative court, like how younger generations will perceive that more conservative court, making maybe this court reform more attractive of a topic. So here's the most interesting thing, I think, and the most worthwhile thing when you think about court reform to think about. So is it a solution in search of a problem? So Paul Clement, who was the Solicitor General under George Bush for many years, was asked to address this question, and this is the answer he gave, and I think it's sort of brilliant. If you think about this, when the Constitution was formed, did it make sense to just have new justices whenever people died or retired? And Paul's answer was probably yes, but it really kind of doesn't make any sense now. So what's changed between the 1700s and now? Well, the biggest thing that's changed is Marbury versus Madison. Judicial review. The original Supreme Court couldn't strike down laws as unconstitutional, but this one can. I read Alexander Hamilton's biography over the spring. So he was interested in a larger federal government, very different than Jefferson, right? He never in his wildest dreams could imagine a government as big and as sophisticated as the one we have now. So no government was seen as big as what we have. But I think most importantly is this sort of factor, but this is very relevant today as well. I think that the Supreme Court justices, the founders, envisioned a legislature that was much more active, vibrant, and functional than the legislature we have today. The Supreme Court has filled in a gap, essentially because it's been allowed to, and because we need decisions on these crucial things. And I don't think for a second that any of our founders imagined a court as vibrant and as active as the one that we have. And we don't have to have a court that way now. So if you're really interested in this topic, I highly recommend just Googling Supreme Court reform. There's an organization that has 9 different items of reform. I'm not going to go through all of them. I'm just going to talk briefly about 2. Obviously, the one that's been in all the debates, Joe Biden can't run fast enough away from trying to have to answer this question, is he interested in adding seats to the Supreme Court? This is popular. As you all know, like the court has had more or less seats over time. It could be done by statute. We currently have a statute that says there's 9 justices. That statute could easily be changed. I'm personally not a big fan of this option because it just could result in tit for tat. Eventually we could have 30 people on the Supreme Court. And unless I was one of them, I can't imagine that being a good system. And sort of where would these additional justices sit? I mean, I know that sounds crazy, but it's a consideration. I personally am a fan of 18 and out, but 18 and out has its own problems. So 18 and out is like you get a seat for 18 years and then you leave. And what's really good about it is it creates a certain amount of regularity. Like every president has 2 seats and that's it unless someone would die. There's some controversy over whether this can be done by statute. I personally don't think it can. So the Constitution basically says judges serve on good behavior. It doesn't say on good behavior and for 18 years. And remember, if like this was made law, it would be the Supreme Court deciding whether or not that could be the law. So it's kind of interesting as well. There's also like a couple problems with this scheme. There would be no effect for a really long time because at least the proposal in Congress right now would keep all the justices that are currently there. So imagine this, like we do 18 and out, but 40 years later, Justice Amy Coney Barrett is still on the Supreme Court. Would be kind of strange. And even if the court, or even if Congress said, that's it, everyone's seat is done whenever we say it's done, it would still take 18 years for this to get in effect because it would take time to cycle through all these new justices. So anyway, I do like that idea, but they've all sort of got some issues. So I'm now going to take a closer look at Justice Barrett. And I'm going to look at her from a number of different perspectives. First, I'm going to start with personally and professionally. So she's not an Ivy Leaguer, she's not an East Coaster, and she's never worked for the federal government, other than when she was a clerk, which we don't really think of as working for the federal government. So that makes her pretty unique, especially among the newer justices on the court. I can't think of a recent justice, other than Justice Sotomayor, who is a New York City prosecutor and a federal judge, who doesn't meet at least one of those criteria. If not, I'm sorry, he doesn't meet all of them. Justice Sotomayor didn't have a federal government career. So she clerked for Justice Scalia. She said in her confirmation hearings, yeah, I see the world a lot like him, but I am my own person. What's very different about her from our last two people, Kavanaugh and Gorsuch, is she does not have a long appellate record. However, she does have cases from Chicago, so there are some interesting cases in that mix. And the other thing that's kind of interesting is a lot of talk about how religion might influence her decision-making. I personally think this is actually a very complicated and a very interesting subject matter. I think it's impossible to sort out how anyone who was raised in a faith and has it as an adult, or even doesn't have as an adult, how they could separate that from decision-making. But it's just particularly interesting in terms of her, because Judge Barrett has been so outspoken about her religious beliefs, at least relatively speaking. And I have to remind people, it wasn't that long ago, if you decided an abortion case on a lower court, you would not be considered for a Supreme Court position. That was how it was done. But we are beyond those days. So Judge Barrett, almost Justice Barrett, describes herself as a textualist and originalist, as a fan of judicial restraint, meaning judges shouldn't get involved in what are political disputes, but of course we could all argue about what are political disputes. And I don't know if she described herself as a social conservative, but she certainly is one by most people's standards, and certainly personally, I'm sure she would agree with that. Her writing is clear, focused, and not flamboyant. So I'm going to talk about how she may impact the issues of the Affordable Care Act, abortion, and guns. And I picked these topics because these are where the Chief Justice has held back. She also has some academic writing and some, she said some things personally, and she's some opinions in this space. She doesn't have a lot of law in any of these categories, but these are interesting because they're places where Roberts is, like I said, just held back. So as you guys all know, the Supreme Court is hearing this ACA case yet again. So what Congress did was in a couple of years ago, they said, and when we get to January 1st, 2019, the shared responsibility payment is going to be zero. So if you don't want to get health insurance, you don't have to pay that tax. So remember, in 2012, the court had said, okay, the individual mandate is a tax because if you don't get health insurance, you have to pay this shared responsibility payment of whatever it might be. Well, now that shared responsibility payment is zero. Everyone is acting as if it's clear that now the individual mandate is unconstitutional. So everyone seems to agree on that, even though that is one of the issues before the Supreme Court. So we all kind of agree on that, but it still will be argued. So the case is going to come down to this concept of severability. Severability is the idea that part of the law that's unconstitutional can be kind of put aside and the rest of the law can remain. So the test for severability is, would Congress have originally enacted the part of the legislation that is still constitutional on its own? So this becomes kind of an interesting discussion in terms of the ACA, because Congress, with John McCain, got rid of that individual mandate, but didn't get rid of everything else. So it sort of looks like Congress was fine with the rest of the law being in effect, because if they weren't fine, why wouldn't they have just gotten rid of it? So Judge Barrett, soon to be Justice Barrett, heard no ACA cases. She had no academic writing on severability, but she had said that the Chief's opinion on whether the ACA individual mandate was a tax was a stretch. But a lot of people probably think that. Even people that like the ACA probably think that. She also signed this petition objecting to the birth control mandate. So all that kind of swirls in the background. Now, this is my own personal opinion, of which I could be wrong about, and we will know more about oral argument. I don't think that Justice Barrett's vote is actually going to matter in this case. So again, my buddy Adam Lichtak says, the arguments against severability are more creative than convincing. I completely agree. So here's what happened last term. Justice Kavanaugh and Justice Roberts, in two separate opinions, two separate cases, wrote opinions on severability. These opinions were essentially love letters to severability. Roberts described severability as a scalpel rather than a bulldozer. And Justice Kavanaugh, like I said, embraced severability sort of warmly. So it is my personal opinion that Justice Kavanaugh and Justice Roberts will vote to say those other provisions of the law that are not unconstitutional can be severed from the ACA. But here's the thing, we don't know. And we're gonna know more after oral argument on November 10th, but we're still not gonna know until the court actually decides. And then I just have to quickly mention, because like you never know what's gonna happen with the Supreme Court, that there is a standing question in this case, whether the parties really had standing to sue. Seems unlikely the court is gonna go there, but if they just wanna get out of this controversy altogether, they almost always have like a little chute that they can pull, like, get us out of this case. And that's kind of standing, like, oh, no one had standing. We don't want to decide this. So I don't think that's going to happen, but I do think, like, you heard it here first, if it does happen. Okay, the second issue where Judge Barrett's views have gotten a lot of attention is guns. So for those of you who heard me talk about guns before, you already know this stuff. The court has gotten 150 petitions in the last 10 years to decide a gun case. So the only thing the Supreme Court has ever said is you have a right to a gun in your home for lawful reasons. They haven't said you have a right to a gun outside your home. They've never said you have a right to a particular kind of gun. There is a circuit split on whether or not there is a right to a gun outside the home. And like I said, 4 justices have said, we want to hear this case, but they haven't heard it because they have been nervous about Roberts. I do think ultimately Roberts will come down the same as his more conservative colleagues. But like I told you, when the court denied those petitions, people were like, what is happening? So interestingly, Judge Barrett, this is where she has the most precedent. That's interesting. So Judge Barrett did have a gun case when she was at the 7th Circuit. So this individual is like a shoe sale. He owns a shoe company or a shoe store. And he was convicted of some sort of white collar crime. So felons in Illinois apparently can't have guns. So he said, whoa, wait a minute. Like, I'm not a dangerous criminal. I'm like Martha Stewart. I mean, give me my gun. And so the majority of the 7th Circuit said, no, you're a felon. You can't have a gun. So what Judge Barrett said was, she dissented and she said, I think you should be able to have a gun because at the founding, the test was, are you a danger? And white collar shoe salesmen are not a danger. So what's interesting is if you look at this doctrinally, typically when courts analyze gun cases, they're going to apply intermediate scrutiny, which is going to be balancing like the interests of the state and the interests of the gun owner. When you look at just history, that tends to lead to a more pro-gun owner outcome. So I want to say that I said this, but I didn't. So I'm just going to give this quote, I'm just going to call the guy out who said it. Stephen Vladeck from the University of Texas couldn't agree with this more. Gun cases are going to be like candy to this new Supreme Court. I think we're going to have a gun case in a hot minute. And the gun owner is going to win big time. I think that's just a sensible prediction based on Judge Barrett's record. So in terms of abortion, this is very interesting. For sure, Judge Barrett is personally pro-life. She was involved in some cases on the 7th Circuit that involved abortion, but kind of peripherally. There was one case where the 7th Circuit struck down an abortion law that required fetal remains to be buried and not cremated. So that was what the 7th Circuit held. She joined a dissent from a rehearing on Bonk saying, I'd like to rehear that case. Eventually it went to the Supreme Court and then back to the 7th Circuit. Another case out of the 7th Circuit struck down, I don't know if it was Indiana or Illinois. They had a state statute on consent for abortions for minors. Again, they struck the law down. Judge Barrett would have had the Seventh Circuit rehear it. So she didn't write any of these opinions. They don't get into any sort of abortion doctrine, but they kind of point in the same direction. But especially for the non-lawyers on this webinar, this is what I want to say. I agree with everyone or anyone who would say Roe versus Wade has never been as vulnerable, probably other than at this moment. But I also think it may still be safe. And I'll tell you why. Like, you have to think about the law in kind of three buckets. This law is bad. I want this law overturned. And I'm a Supreme Court justice with the power to overturn this decision. This law is bad. I think most lawyers think that Roe versus Wade was an oddly reasoned decision. And it's probably something the legislature should have decided, but didn't. So that's one category, but it doesn't kind of mean much. There's probably a fair amount of lawyers out there, conservative lawyers in particular, who would want Roe versus Wade overturned. But there's an awful lot of people, I think, who would have a hard time as a justice overturning it. And so I think Justice Roberts falls most in that category. He might ultimately vote to overturn Roe versus Wade, but he clearly wasn't anxious to do it in the last couple of years. And this is for the non-lawyers. And this is like the most important thing. And it's the thing that people forget. The Supreme Court literally never has to take the question of whether or not they want to overturn Roe versus Wade. They can simply never consider it. They can never take a petition that says it. So that's important to remember. I don't think anyone, I think we all can kind of agree that abortion cases are going to probably die, or abortion jurisprudence might die by 1,000 cuts. But that is different symbolically and in other ways from overturning Roe versus Wade. So just on some other sort of controversial issues, getting a fair amount of attention during the confirmation process was Judge Barrett using the term sexual preference, because it kind of implies that sexual orientation, like the concept there is that this isn't a choice that a person makes. So people saw that word as sort of dated and maybe indicating that she wasn't quite with the times. I do not think in any way, shape, or form that the same-sex marriage decision is vulnerable. I cannot see Roberts, Kavanaugh, or Gorsuch having any interest in revisiting that issue. Climate change. Senator Harris asked Judge Barrett if she thought climate change was happening. I was kind of surprised by her answer. She said, well, that's a political question. And I was surprised by that because I think that we all agree that the solutions to climate change are very political, but maybe not whether it's happening is so political. But here's the deal. Her views on climate issues really are not the ones that matter. The persons whose views matter are Kavanaugh, and they're also much more well-known. So Kavanaugh sat on the DC circuit. The DC circuit, my husband always asks me, what's different about that circuit? They have jurisdiction over the federal agencies and decisions that come out of them. So Justice Kavanaugh has had tons and tons and tons of cases on environmental regulations of all kinds and just regulation in general. Skeptical of regulation, most conservatives are. So he's the person to keep your eye on. Again, Judge Barrett seems personally opposed to the death penalty. The Catholic Church's official position is against the death penalty exclusively. The Supreme Court has had many, many Catholics who have been seemingly fine with the death penalty and supportive of it even. I don't expect Judge Barrett to be different, but time will sort of tell on that. So, the kind of question for state legislatures is beyond all the controversy, where would Judge Barrett be in a mine run case and just like a regular case that involves federalism or preemption or the First Amendment or the Takings Clause or qualified immunity or the Fourth Amendment, speech, religion, just those regular kind of things. And the answer is we really don't know that much about her because she wasn't in the Seventh Circuit very long. And her predecessors, or rather like Gorsuch and Kavanaugh, came with a completely different kind of record. Justice Gorsuch was on the 10th Circuit for 10 years. He wrote with a lot of flair. He liked to pontificate and make suggestions about Supreme Court precedent that should be overturned. He's kind of over the top. Justice Kavanaugh had every hard-hitting issue, and he had it on directly: guns, abortion, the ACA. There was no academic writing that anyone was looking at related to Judge Kavanaugh. He hit the hard issues. From what I've looked at, beyond the really controversial subjects, Judge Barrett, most of the cases that I looked at just involved her applying precedent, and she seemed to do that well, competently, carefully, thoughtfully. Probably the biggest difference, I wouldn't describe Kavanaugh as flashy at all, but Justice Gorsuch, like I said, a lot of flair, a lot of flash. This is a woman who does not care to draw attention to herself. When she said, these confirmation hearings are going to make me and my family miserable, I believe her. This is not, like sometimes I felt like Justice Gorsuch, almost liked playing the annoying game with Congress, but Judge Barrett, no, that's just not who she is. So, it's always impossible to put aside your political beliefs, like your own personal political beliefs. So those who you've heard me speak before have probably heard me say, my ideal justice, and I have local government, state government's the same, is a pragmatic, moderate conservative. And who does that sound like? Chief Justice Roberts. He is my ideal justice. Conservatives are very good on things like public employment, police issues, qualified immunity, just kind of closing the courthouse door. In theory, they're better on federalism and preemption. I would say the biggest downside of them is they're a little bit more skeptical of government in general, but I am terrible in takings cases. I just think, we're going to have a rough time with those. But in general, conservatives can be very good. So I looked as closely as I could, considering she only has 3 years of cases, at Judge Barrett's precedent on the Seventh Circuit for free speech. This is an area where conservatives and liberals are both very hard on state and local governments. I would say her positions were not anti-government. If anything, they were more sympathetic to government than I would expect. Part of that might be that she was in a lower court role, but she certainly could have been worse on those issues. There's kind of a notorious qualified immunity case. Just very briefly, it involved this man who was accused of killing his mother. And the police officer had all kinds of evidence that exonerated the guy and just didn't put it in the warrant application, just didn't do it. And he wanted a qualified immunity. And Judge Barrett was like, no. And people are like, this might indicate she's more open. No, it just indicates she has common sense and can apply the law. She decided one takings case where she wrote the opinion, and it actually, get this, it came out in the last month, and it had to do with building the Obama presidential library. But she had some polite word for the claim, like it was unusual or different. It was a polite way of saying, this is a crazy claim and I don't know why you brought it. But she didn't handle it like that. She did it thoughtfully and methodically, but you can't take any conclusions from her, like deciding in favor of the city of Chicago. She's been characterized as pro-employer. I think that's probably fair. She had an N-word decision that she's gotten some criticism for. She didn't say it could never be a factor, but in the case she had, it couldn't be the only factor. Interestingly, Kavanaugh also had a case like that, and he came down differently, saying a one-time use of the N-word can be enough to create a hostile work environment. So I thought that was just kind of interesting. She has a couple tax cases. Most of them don't really involve issues of interest to state and local governments. There was one where she allowed taxpayers to bring a claim in federal court. So that's not great, but it's one case. It's hard to sort of know what to make of it. So in my last couple of minutes, I'm going to talk about the Supreme Court COVID-19 docket and some cases on the docket this term. So the court has heard all kinds of cases related to COVID that it would not have otherwise have heard of. And they have ranged a gamut of issues, but I'm going to focus on stay-at-home orders and judge-made changes to election laws, just in the interest of time. So here's the bottom line. The court has not overturned any stay-at-home orders. All the stay-at-home orders the court has allowed to stay in place. Lower courts have also upheld these decisions. And the Supreme Court has almost overturned all judge-made election changes, except one out of Pennsylvania, which we're going to spend a little bit of time on. So the bottom line is it's hard to get the Supreme Court to overturn a lower court decision on an emergency basis. Basically, the lower court has to have gotten the law wrong. That's kind of what this slide says. The court heard 4 cases, like I said, on stay-at-home orders. Most of them, the challenge was speech was being treated better or being treated worse. And like I said, court has been very sympathetic of what state and local governments have done. And in fact, like this quote was being sent all around when the court issued this decision out of California. Basically, the court is saying federal judges should not be involved in deciding whether a stay-at-home order is good law or not. These stay-at-home orders have to be done quickly. They had to be done carefully. And the decision maker should be someone close to the people who can be responsive to the science and all that. Beautiful quote, the Chief Justice at his very best. So in terms of judge-made changes related to the election, I had a complicated slide with every state and what the issues were, and it just got to be too much. So basically, as you all know, people are voting in large numbers by absentee and mail ballot. And some courts have said, due to COVID-19, we're going to strike down this requirement of an absentee ballot. The most probably common example is the witness signatures. You don't have to get a witness signature because people are living alone at home in COVID and they can't find someone to do it. And so for COVID reasons, we're just going to strike that out of the law. So by and large, the Supreme Court has said almost universally, no, judges, you can't rewrite election laws just because of COVID-19. But then the plot thickens, okay? This is where it all kind of gets crazy. So last week, the Supreme Court in a 4-4 decision let the lower court decision stand, where the lower court had said, in Pennsylvania, we can count ballots received after election day for 3 days. So we know Chief Justice Roberts joined the liberals. And so this is considered a really big deal. We don't know why the Chief Justice voted with the liberals. It's interesting to note that the Secretary of State did not disagree with this. So it was the Republicans and the Democrats fighting. It wasn't like the Democratic Party wanted this, but the state didn't want it. The state was fine with counting ballots 3 days later. Here might be what the real issue is. Pennsylvania Constitution, I'm not going to read it to you, but you can read it yourself, basically says, if there is a way for people to vote in the state, by God, Pennsylvania should guarantee it. It is just like a celebration of voting in Pennsylvania. I bring this up for this reason. The Supreme Court typically does not get involved in issues just involving state law. And one way of looking at this case, and it might be the way that the Chief Justice is looking at this case, is that there's no federal issue here. The Pennsylvania Constitution says people should be able to vote in Pennsylvania. If that means state statutes are struck down, so be it. In Pennsylvania, we vote. And so that might be one of the things that is happening in this case, but the plot is thickened. And that is what the court had done before was they just said on a temporary basis, we're not going to get involved in this case. We're just going to let the Pennsylvania Supreme Court decision stand. Now, the Republican Party has said, Supreme Court, we want you to decide the issue on the merits. Can Pennsylvania count ballots received late? You, Supreme Court, give us a full ruling. We don't know what they're going to do about that, but we do know when they do something, whatever they do, that Justice Barrett will be on the bench. So people ask me, Lisa, is the Supreme Court going to decide the 2020 election? And I say, well, I don't really know, but I can tell you the theories out there that they might decide it. So it's only really going to be an issue if the election is close. And, you know, Biden looks really far ahead in swing states, but anyone who trusts polls, I would have to question at this point, given what happened 4 years ago. And it's just important to realize this too, that in a bunch of swing states, Pennsylvania, Michigan, and Wisconsin, specifically, all the ballots will probably not be counted that day, but in Florida, they will. So there's basically 3 theories as to how the Supreme Court could decide the election. I'm just going to tell you what they are very quickly. The first theory is that the Supreme Court has already decided the election, and that is this Pennsylvania ruling. They've also, ruled in other cases too, but ultimately, whatever they decide to do in Pennsylvania could, ultimately make a really big difference. The second theory is this, and it kind of relates to what I was saying about Pennsylvania. One of the theories is that what could happen is that instead of having a Bush versus Gore, we could end up with a couple of swing states having election controversies, but that those controversies wouldn't raise questions of federal law. They would just raise questions of like state law interpretation, in which case the Supreme Court would never get involved. So that's a possibility as well. And so that's kind of like a Bush versus Gore, but at the state Supreme Court level. So to really get a Bush versus Gore, what would have to happen is this, I've been told, is there's this Electoral Count Act that basically if an election is deemed a failure, the state legislature can kind of come in and replace the the Electoral College. It all gets very complicated. I can't go any deeper on that, but there are two articles. There's sort of like the junior varsity version and the varsity version. If you're interested in that topic, I highly recommend both of them, but those are some of the paths that, we could get there. So in terms of counting the votes, it's interesting that Judge Barrett, during her confirmation hearing, would not say if she would recuse herself or not, if it all came down to a Bush versus Gore sort of scenario. I think if she wasn't involved in the case, very likely Roberts would probably sign with the liberals. If she was involved in the case, I feel Roberts would be almost forced to join the conservatives so as to not leave her hanging as the only conservative joining the conservatives. So I was supposed to take 10 minutes for questions, but I've just got two cases that I'm going to talk about very quickly, and then we can take some questions. But before I do that, these are cases that are going to be decided going forward. I just want to mention very briefly that the Supreme Court is going to be deciding whether or not the census number for apportioning House of Representatives seats can include undocumented, or rather exclude undocumented people. So the court will be deciding this question probably before the end of this calendar year. But the Trump administration has not changed the census number for apportioning funding or for state redistricting. So I'm just going to call this the Arizona voting case, maybe for obvious reasons. Why this case is so interesting is that it's the first voting rights case since Shelby County, first major voting rights case since Shelby County that is kind of in response to Shelby County. So in Shelby County, the court held for practical purposes that there would no longer be any preclearance. So if you were one of the jurisdictions that had a history of discrimination, before you had to get election changes pre-cleared. After Shelby County, no preclearance. So what happened was advocates said, we're going to turn to Section 2 of the Voting Rights Act, and that's where we're going to bring election-related cases. So Section 2 of the VRA prohibits intentional discrimination and practices that result in the denial to vote. There's two issues in this case. One is out-of-precinct voting. So in Arizona, if you vote out of precinct, your vote is basically just thrown in the trash. None of it can be counted at all. And the other one is third-party ballot collection, where basically you give your ballot to someone and they turn it in. The Ninth Circuit said that both of these practices, or getting rid of, well, let me back up. The court said that out-of-precinct voting, what Arizona did was it was disallowing all these ballots, and the court said disallowing all the ballots without counting them for president, say, even if they were wrong, violates the Voting Rights Act because minorities vote twice at the rate of whites as out of precinct voters. And also, there's just a lot of reasons that people vote out of precinct in Arizona that seem to be somewhat unique to Arizona. So for a long time, Arizona had third-party voting collection, then it went away. And interestingly, Arizona tried to get this pre-cleared and was unsuccessful. The court, again, the Ninth Circuit said this violates the Voting Rights Act because so many more minorities do this third-party ballot collection. A lot of good anecdotal evidence that it was more common for minority voters than other voters. The Arizona Republican Party basically says, like, Arizona's voting rules are neutral. Everyone has an equal opportunity to vote. Just because this falls more heavily on minorities doesn't mean it violates the law. And doesn't mean that Arizona should have to change everything to just accommodate minority voters when they have the same access to voting as everyone else does. So this was an en banc decision. The Ninth Circuit was kind of all over the place. They had just judges voting in all different, dissent, majority, concurring, et cetera. And Judge Barrett does not have much for voting rights cases, if anything at all. So before we take questions, I'm just going to talk very briefly about BP versus Mayor of the City of Baltimore. This is a very, very complicated case. It's also about two very, very different things. It's first about the ability of state courts to decide cases involving state law in state courts. And it's also about the future of climate change litigation. So one of these has it has a very strong federalism implications. So here's the issue, and it's a real mouthful. Whether a federal appellate court may review all the grounds upon which a defendant claims its case should not be sent back to state court when one of the grounds the defendant alleges is specifically listed in the statute as a basis for federal appellate court review. If you don't understand that question presented, you're not alone. The facts of this case, fortunately, are very easy. Baltimore sued 26 oil companies over climate change and wanted the case to be heard in state court. So basically, cases can be heard in federal court or removed to federal court, if you will, if the case involves an issue where the federal courts have jurisdiction. So BP said they had 8 grounds to say, federal court, you have jurisdiction over this case. And one of those grounds was the federal actor doctrine. It's basically the idea that even if you're a private company, like the federal government is basically like forcing you to do whatever it is that you did. So a federal district court looked at all the 8 grounds for removing the case to federal court and said, nope, none of these grounds are legit. There's no federal court jurisdiction in this case. It's going to go back to the Maryland state court. But the plot thickens. There's another federal statute that says federal courts of appeals can review in very, very limited circumstances for if there's a federal officer removal claim or something similar, they can review these denials by district courts of federal court jurisdiction. So what BP wants is for the Fourth Circuit to review all 8 grounds it claims it has federal court jurisdiction, because one of the grounds is included in the exception that allows federal courts to review removal jurisdiction. So you might be wondering, why does BP want this so bad? Well, what they want is they want to be in federal court. And they want to have one more chance for a federal appellate court to say, oh yeah, this case should be back in federal court. So why do they want a federal court to hear this case rather than a state court? Well, they think, and they're probably right about this, that federal judges won't be all that familiar with state law because that's not what federal judges do every day. I think they also think that federal judges may be more skeptical of climate change cases, which is, again, what they want. So the Fourth Circuit ruled against BP and basically said, you have 8 grounds for wanting us to review federal court jurisdiction. Only one of them is listed as an exception to the statute. We will review that exception. We will not review anything else. And it's because they had a 1976 case that said, don't review all the grounds if they only have 1 grounds from the exception. So this issue is a huge one in climate change cases. There are 3 state and local government climate change cases brought against big corporations. They all raise the issue of whether or not the case should be heard in state or federal court. So another important fact for why these cases are being heard in state court is that the Supreme Court has said that federal common law doesn't apply to these. It's another reason for why state and local governments want these to be heard in state court. But it's important to highlight this issue of, do we review all the grounds when they bring up one of the grounds for why we should reconsider the removal decision? This issue has come up in all kinds of cases that have been brought in state court. A defect in an airplane, an eminent domain case, Flint water crisis. All these cases were brought in state court because they involve state law issues. And they have nothing to do with climate change. So the case is bigger than it may appear to be. So with that, I'm sorry I went over my time, but I'm happy to take a couple questions.
Okay, really quick. Thank you, Lisa. That was really excellent. And very thorough. So, maybe folks just don't even have questions because you've really just answered everything. But really quick, we do have a couple. So first of all, so you mentioned that Chief Justice Roberts has worked hard to maintain the institutional credibility of the court. So one question is, have other justices indicated a similar priority? Or is that only coming from him? And how might that play out?
So I love that question. And the reason why I love it is because I think it's completely ridiculous that the Chief Justice should have all that responsibility on him and that we would think that that's okay. I'd like to think that all the justices, conservative, liberal, would have some interest in that, in the institutional viability and the institutional credibility of the topic. Off the top of my head, I would say the one justice that I think thinks along those lines is Justice Kagan. She's a liberal, but definitely not a knee-jerk liberal. I think, if there's someone who wants to pair with the Chief Justice, wants to sort of find middle ground and common ground, someone who's willing to sort of join in opinion if the chief will get it narrowed the way she wants. I think she's got some of that. I wonder if Kavanaugh might grow into that role. Gorsuch to me seems, like I said, kind of stuck in his ideology and his worldview, but I can't help but wonder, like I said, if Kavanaugh might find himself there at some point. And I don't know Judge Barrett well enough to sort of know, but if there's judges that try to create compromise and are willing to join an opinion if they've been given a little, it's Kagan and Breyer on the liberal side.
Yeah. Okay. And then one other question is, and maybe a good question to end on because we're at 3 o'clock on the dot, is what cases does the State and Local Legal Center anticipate filing in this term?
Okay, great question. So we will actually file in that climate change case. We won't focus on climate change at all. We're just going to focus on the notion that when state law arises, that those cases should be heard in state court. They shouldn't be moved to federal court just because someone has some idea of one, non-exception that they want a federal court to hear. So we're going to file in that case. We filed in a bunch of cases earlier in the term that were holdovers from last term. Another one that NCSL is actually going to join is the case, we call it U versus P, because it's two really long names. The question is whether if a local government or a state government has a policy that's unconstitutional or arguably unconstitutional, and they change it, and the parties only want $1 in nominal damages, they don't want any more money than that, if that just moots the case. Or if the case has to continue, full more litigation for them to get their $1. So NCSL will also file in that brief. And the court still probably has 25 more petitions to grant. So we still have a lot more cases this term where the SLC may file a brief.
All right, excellent. Well, thank you, Lisa, for that, just great presentation as always. And we're at 3:01 here, so I think we're going to wrap things up. I will hand it back to Susan for any concluding remarks.
Just thank you for tuning in, everybody. This will be recorded and we have the link in the chat, so copy paste that if you want to go back and listen. Again, thanks for coming, and we look forward to doing some more programming in the near future. Thank you to Lisa for an excellent presentation, and to the criminal justice team at NCSL for assisting with this recording. And with that, I will bid you adieu and have a great rest of your Monday.
Thanks, everyone.